Welcome to Justice Matters. I am Denise George, Attorney General of the U.S. Virgin Islands. Justice Matters is a program aimed to inform, encourage, and engage you with knowledge of Virgin Islands laws that affect our everyday lives and our community, including insightful discussions with special guests on the laws and related topics so you can be empowered with knowledge to make a difference. Today's topic is to plea or not to plea. The pros and cons of plea bargaining. We will have a lively discussion with one of our own top prosecutors on this often debated and controversial topic that very few people really understand. You have seen the headlines of defendants pleading guilty to all sorts of crimes. So, what is a plea bargain? Sometimes called a plea deal or just a plea, and it often conjures up mixed feelings in our community. A plea bargaining is a negotiated agreement in a criminal case, usually offered by the prosecutor or assistant attorney general in this case, in which the criminal defendant gives away the right to a trial by accepting guilt to any charge or charges in exchange for some benefit from the government prosecutor, such as a dismissal of some charges or jail time that is less than the maximum punishment. Here's how it usually works in summary. First, the prosecutor decides whether to offer a plea, when to offer it, and what's contained in the plea offer. The prosecutor makes a plea offer to the defendant's attorney to maybe plead guilty to a lesser crime with lower maximum prison sentence that the defendant would be facing if he were to be convicted after trial. Then, if accepted by the defendant, it eventually goes to court, where a judge reviews the plea agreement to assure the defendant entered it voluntarily. The defendant must state in open court, among other things, that they're pleading guilty because they are guilty, for the court to accept the guilty plea. Plea agreements are very common throughout the nation. According to the Innocent Project, 97% of criminal cases are disposed of by way of a plea bargain. So why is plea bargaining so favored in our justice system? Mostly judicial economy, efficiency, and certainty. Say, for instance, when the prosecutors have evidence that someone is guilty, a plea is a chance to secure a conviction and a punishment without the time, expense, and uncertainty of trial, or taking the risk of getting an acquittal or not guilty verdict. The defendant, on the other hand, has a chance to lock in a sentence that's much more lenient or much more benign than a maximum sentence that they might be facing if they were convicted at trial. The courts highly favor pleas because plea agreements administer justice while reducing the criminal docket and extraordinary expenses of trial. Just think, there are hundreds of criminal cases handled in the Attorney General's office right here in each district, St. Thomas and St. Croix, at any given time, and growing because crime never takes a holiday. Imagine the backlog since COVID shut down. There is no way that the Superior Court system can have trials for all of these cases. Even some of our criminal laws are made to facilitate plea bargaining, particularly for first-time, petty, or non-serious and non-violent offenses. For instance, Title V VIC Section 3711C. We usually just refer to it as 3711C and refer to it as probation without conviction. It says, upon a finding of guilty or upon receipt of a verdict of guilty or a plea of guilty wherein the alleged offense did not result in the personal injury or death of any person, or where no deadly weapon was used in perpetrating the crime, the court may, without entering a judgment of guilty or accepting the plea, and with the consent of the defendant, defer further proceedings and place the defendant on probation, provided the accused has never been convicted of a misdemeanor or felony. Upon fulfillment of the terms of probation, the defendant shall be discharged without court adjudication of guilt and an order shall be entered expunging the finding, verdict, or plea of guilty and all records. Another program under our laws that is often used in plea agreements for first-time offenders who commit non-serious misdemeanor offenses is the Pretrial Intervention Program, or as we call it, PIP. In summary, to qualify, the defendant must meet certain requirements, including having no criminal history whatsoever. PIP is a program of community supervision and services. In lieu of going to trial, the first-time offender's case is diverted away from trial and into the PIP for a period of time. Upon satisfactory completion of the requirements of the program, the defendant's case is dismissed and the record expunged. Also, our criminal statutes give a range of exposure to incarceration within which a prosecutor and a defense attorney can negotiate. So, for instance, let's say for the criminal offense of assault in the third degree, whosoever under circumstances not amounting to an assault in the first or second degree assaults another person with intent to commit a felony shall be fined not less than $500 and not more than $3,000 or imprisoned for not more than 5 years or both. The not more than means anywhere from 0 time in prison to a maximum of 5 years for this offense, so there is leeway there to make plea offers for less than the maximum within that range. Still, any offer is at the discretion of the Attorney General or prosecutor. That being said about the pros, there are also cons with the plea bargain process. There are concerns by some that many defendants enter these agreements without fully understanding the implications, such as judges are not required to follow a plea bargain agreement, which means that although the prosecutor and defendant may agree to a plea bargain, a judge can void that agreement, and the judge can impose a longer sentences or decide that the sentence or no sentence should be imposed. And plea bargains eliminate the chance of an appeal. So if a case goes to trial and defendant loses, he normally would have a right to appeal. However, if he pleads guilty, that right to appeal is either limited or completely gone. Also, some people believe that the plea bargaining process may be coercive for an innocent defendant who pleads guilty to a less serious charge just to avoid the risk of a conviction on a more serious offense. So how about those pros and cons? And what's behind arriving at a plea offer? Joining me now is Deputy Attorney General Eric Chancellor, who has unique perspectives on plea bargaining. The Deputy Chancellor was invited just a couple years ago by the State Department to give a talk in the country of Montenegro on plea bargaining. And we're going to talk a little bit about that. Welcome, Attorney Chancellor.
Thank you, AG. I'm happy to be here to talk on this very interesting subject.
How did you get involved in there to be able to talk about plea bargaining and everything, and why?
Well, it was very interesting, actually. A couple of years ago, while I was criminal chief in the St. Croix division, I got a call from someone from VIPD asking if I would host this delegation that came over from Montenegro with State Department representatives. Montenegro is actually a country in the Balkans, and it used to be part of the former Yugoslavia, which was one of those Soviet satellites countries. Interestingly enough, it only became an independent country in 2006, so it's relatively new. So the delegation come over, and they were doing a tour of the United States, and they passed through the Virgin Islands, and they were looking at the legal systems, and it was actually a group of prosecutors that the State Department was touring throughout the United States. They came here, and they came over to our offices, and we had a conference, basically a sit-down, and they got to ask me questions, and I answered them as best as I could, of course, and they were a great group of people. And after they left, the State Department representatives who brought them along reached out to me and asked if I would come to Montenegro, at their expense, of course, yes, to give a presentation on plea bargaining.
And it is an American system. Right here in America, it's like 97% of the cases approximately are settled by plea. So it's really, really very, very much used here.
That's true. It is. And that's the problems that they've been having over there. That they have a backed up court system, just like we do. And they need a mechanism in order to get through the deluge of cases that they have.
Okay,
something more efficient. And that's what we have. And this is one solution that they could use.
Well, why is it a solution?
Trials take a lot of resources, energy, and skills to put on. So our system is deluged with the amount of cases that we have. If we had to go to trial and give this formal jury trial process to each case, we would be much further behind than we even are right now. The system wouldn't be able to handle it. Fortunately or unfortunately, plea bargaining has become an integral part of the American system. So much so that it's recognized by the Supreme Court. It's incorporated into our laws. It's just part of the culture of the legal system now. So you look at how long it takes a criminal case to be resolved, or even a civil case. Civil cases can even take longer. So you may have a case language in the court system, and it may be 1, 2, 3 years before it can actually get to trial, just because of the amount of cases and the amount of different procedures that the court has to deal with. So it takes a lot of time. Cost-wise, there's tremendous cost involved in putting on trials. Well, first of all, the court have to pay jurors. Every time you have a trial, the court has to bring in the neighborhood of 100 jurors. You have to pay each one of them.
And that's what we're there for, right? But
it is what we're there for. That's part of the job. We all accept it. We know we have to work hard. But during trial, a prosecutor is working anywhere from 12 to 14, sometimes 16 hours a day, because you constantly have to be preparing. In addition to that, depending on the trial, you may start preparing for that trial 2-3 months in advance, spending all your time preparing for it, depending on how complicated. Because remember, trials are very complicated, and they take a lot of skill.
What are the considerations in that you go into to assure that if you're going to make a plea offer, when we make a plea offer, that it has to be reasonable and to accomplish the objective of what we need to do in getting the conviction that we need? What kinds of things did you look at to assure that the crime fits the punishment?
Interesting question. You first have to understand that most statutes, practically all statutes, have a range already. So the legislature has said, this is the range that you can consider for a particular crime that's occurred. And we can go anywhere within that range. And I think that that's a recognition that we have to treat each case on an individual basis. We're not going to ask for the maximum.
So it's really on a case-by-case basis, right?
Yes. So some of the things we look at would be the nature of the case, right? What is the crime that's being charged? How serious is it? You might look at the background of the defendant. Is this a repeat offender? Is this somebody who is a first-time defendant in the law, first-time arrested? How the victim, that's very important to us also. We look at the victim. How does the victim feel about it? How can the victim be made whole? The victim isn't always made whole by a defendant going to jail for a long period of time. And I see that especially in a lot of cases where you have family members. It might be a domestic violence situation where that family member doesn't want that individual to go to jail so much as they want that individual to get help. And in plea bargains, we're able to do that. We're able to make sure that that family member, that defendant, gets substance abuse counseling. They might get anger management counseling. They'll have to do community service.
Well, it depends also on the circumstances and the nature of the offense, because domestic violence, of course, runs the gamut. So there are some times that the offenses are so serious that it would warrant jail time.
Absolutely.
Irrespective of how maybe the the victim even might think about. So that's not the only aspect. Whether it's a guilty plea or a conviction by a jury or a judge, it's still a conviction. Either way, irrespective. So the goal in getting a conviction, if there's a way to get a conviction, a reasonable conviction, outside of having to go through trial, that's the part, right, that comes in with the efficiency and judicial economy and the pros of that. Right?
Yes, exactly that. The plea bargain assures us that someone, the defendant, will be punished for that crime.
Mm-hmm. So what about the cons?
Well,
I mentioned a couple concerns that, well, some have, that sometimes an innocent defendant could plead guilty to a lesser charge just because it's better to face, let's say, the 2 years or 3 years of the lesser charge than it is to face the 30 years of the larger charge. So then the fear is that some are, who might be innocent are kind of not coerced, but actually convinced to plead guilty anyway.
Yeah.
What are your thoughts on that? And what can we do, or what do we do in order to alleviate that kind of thing happening?
I think that's a legitimate criticism. That's possible, that can happen. I will say that the majority of people, the vast majority of people who plead guilty are in fact guilty. Mm-hmm. You may have some in there who may believe that pleading guilty is more beneficial than going through a trial. Mm-hmm. It's very important that people be represented in our system, that you have competent counsel, that you know what you're entering into. And in fact, when you go before a judge with a plea agreement, there's a whole colloquy that the judge goes through where they ask you, have you been coerced? Are you satisfied with your lawyer, what your lawyer has advised you? Have you told your lawyer everything you need to tell your lawyer about your charges? So those are things that is built into the system that helps alleviate those concerns of innocent people being roped into some sort of plea deal.
And I've never really seen something like that happening, but that's not to say that that could happen, because I could see how a scenario could be like that.
Yeah, especially now, there are also safeguards with counsel. It's very important, the defense counsel.
That is essential, yeah.
And there's a whole body of law that's grown now around plea bargaining and the duties of a defense counsel towards their client. Now, even though a person doesn't have a right to have a plea agreement, I wouldn't be surprised that within the next few years, it does become a right, because it seems to be moving in that direction. So even now, let's say a prosecutor offers a plea agreement to a defendant and his counsel does not convey that offer. The defendant then goes to trial and gets convicted. That defendant now has a claim for ineffective assistance of counsel and can get his conviction overturned and a new trial because of that. And that's what the Supreme Court of the United States has said. Even now, once a case is started, the court puts it in writing in the scheduling order that
by this date there's a plea offer.
Exactly.
And they will, and the court will ask you, the prosecutors, when you get to court on a status conference, have you offered a plea? Now, they can't make the prosecutor offer a plea, but it's definitely encouraged. If you have a criminal offense and it's so egregious, and it requires punishment, because remember, punishment is a part of, in our system, that sends a message to the community. As far as what happens, it's a part of enforcement. So how much does that factor in?
The more serious the crime, of course, the more likely we are to say, hey, we're going to take this to trial. We're not going to offer you a plea. Now, even if a trial is very serious, there's always a plea you can offer because the
We have a lot
defendant
of
may be
open.
willing to plead to the
That's
charge,
true.
to the highest charge.
Exactly.
And so, yes,
And that
we
has
have to
happened.
give them the plea, and that's happened.
Yeah.
I've sent out pleas where we may have charged the defendant with 5 counts, and I give them a plea to 1 count and dismiss the others because that plea is to the highest charge, and they're going to get the maximum sentence anyway.
When it comes to sentencing or to presenting the plea to the court, what is it that the courts look at?
Well, I know that the court would consider a defendant who freely and voluntarily accepts responsibility in a more favorable light than someone who may have gone to trial and continues to deny in the face of a jury verdict, in face of all the evidence, and defiant about what they've done. Some people believe that the prosecution has too much power, that we hold all the cards.
And in a lot of ways, yes, the prosecutor does hold a lot of the cards. I mean, we have to take that responsibility. And I think that, but we do have responsibilities to administer justice as well, you know, to make sure that something is just and fair. What happens if you go to trial? In most cases, what happens?
Well, it's a fact that people who enter plea agreements, accept responsibility, and enter plea agreements do less time than people who go to trial and lose. That being said, the vast majority of people who go to trial lose. Prosecution are found guilty.
Doing with
right.
our office,
the majority.
Right.
Right.
With our office, the rate of conviction in trials is very, very, very extremely high.
It's very high.
You win.
And all over the country it is.
Yeah.
But the fact is there's also a substantial minority that are acquitted.
All kinds of things.
All kinds of things can happen. Therein lies one of the dilemmas of plea bargaining for both sides, right? Because the closer you get to trial, from the prosecutor's standpoint, your case can either get stronger or get weaker. I've had it where the case didn't look very good in the beginning because a witness recanted, sent in a letter. But by the time trial came around,
they were ready to go.
And I talked to that witness again, was ready to go, and we went to trial and we got to conviction. And the defendant was banking on the witness not following through and not coming forward. But the witness came, and we were able to get a very good conviction on an important sexual assault case that we had. So sometimes it gets better.
Yeah, and the thing is, it's like we're always ready to go to trial.
As prosecutors, I always say that our goal is to get the highest conviction on the highest charge possible and get the maximum sentence possible. That's once we go to trial,
that's it.
That's what we're doing. So we're required to plea bargain to a certain extent before. But once the determination is made by the defendant that he's not going to take the plea bargain, and we go to trial, you get convicted, we're going to be asking for the maximum. We're not going to be asking for the same thing that we were offering you before.
What about the victims? As I always say, the prosecution is the voice of the victims oftentimes in our system, the voice of the victims and the voice of the witnesses, particularly victims. What about the victims, and how important are the victims in this process?
We have the Victims and Witnesses Act, Victims Bill of Rights Act, I think it's called. But it delineates rights for victims and witnesses in criminal cases. One of those rights is to have access to the prosecutor to discuss a case and about the considerations that the prosecutor is giving for plea bargaining. However, we take their concerns seriously and we take what they say into consideration in offering plea agreements.
Thank you for that. And that's really a good place to close. Well, as you see, plea bargaining is here to stay because our system of justice would collapse if we're not able to plea out some cases. But the important thing is that we make sure to safeguard these cases so that justice is done in each and every one of these cases. So thank you again so much for joining us on Justice Matters.